September 23, 2025. We're marking that date as a confirmation of charges hearing for former President Digong Duterte.
Now, between now and beyond that date, anything can happen. Even the certainty of a trial for the tough-talking ex-leader is not promised.
5 months ago and a few weeks to go, or 5 months and a few weeks to go, and what legal maneuverings can we still expect to come out until Digong faces the court again?
And as promised, we have the spokesperson and the Public Affairs Unit Head of the International Criminal Court, Dr. Fadi El Abdallah. Welcome to the big story and good evening from Manila. In your previous interviews, you have said that there are actually two facets to the issue of jurisdiction of the ICC. One is covering the alleged crimes against humanity, the period of the alleged crimes, and second, the surrender of the Philippine government to the ICC's jurisdiction of the former president. May you elaborate on this, Doctor, and also more on the second part, because the first, in the first instance, there is jurisprudence from the ICC and even from the Philippine Supreme Court.
Well, I'm not sure that I fully understand the question, but from the point of the question of jurisdiction, despite the fact that the Philippines withdrew from the ICC Rome Statute, the withdrawal is only affecting what happens after the withdrawal becomes effective, which was a year after the deposit of the withdrawal instrument within the Secretary General of the UN. So for the ICC, the jurisprudence has been always clear that the ICC had jurisdiction over the crimes that were allegedly committed during the period when the state was a state party. So for the Philippines, during the period from 2011 to 2019. And during this period, crimes allegedly committed that may be considered as war crimes, crimes against humanity, or genocide would have been under the ICC jurisdiction. And the withdrawal of the Philippines does not affect this jurisdiction, and this jurisdiction can be activated, so cases can be brought before the ICC in relation to these crimes, even after the withdrawal of the Philippines. So this is a main element, that the investigation and the cases can start after the withdrawal, but they are only related to crimes that allegedly happened during the period when the Philippines were a state party. Now, the issue of the arrest and surrender of Mr. Duterte, it is something for which the court has always showed appreciation to the Philippines' commitment to the international accountability mechanisms. And it is important because we believe that justice should prevail, that truth has to be revealed, and there is a process for that, which is, in our instance, the international level process before the International Criminal Court.
Dr. Abdallah, the chief legal counsel of the former president has indicated that he will bring this matter even before the confirmation of charges hearing. And so that is why we wanted you to elaborate on how this turnover or surrender by the Philippines, which was no longer a state party to the ICC at the time.
Well, I think the main element, as we had already indicated, is that the ICC has jurisdiction over the alleged crimes because they happened allegedly during the period when Philippines was a state party. Now, the surrender of Mr. Duterte to the ICC is something that was, of course, the decision of the Philippines authorities. And if there is any question about whether it was lawful or not, it would have to be submitted to the judges. I cannot speculate what the judges might say, and then we will see what would be the outcome. But of course, even states that are not parties to the ICC Rome Statute, they can cooperate with the ICC on a voluntary basis. So the question is, I think, might be raised by the defense about the lawfulness of the arrest itself. But this has to be decided by the judges. I cannot speculate on it.
Right. Dr. Abdallah, on the matter of some witnesses who are in the custody of the ICC, it has been disclosed by by some counsels of the victims that there are at least 2 in the custody of the ICC. Would you be able to confirm this, or is this something that is confidential?
We don't have witnesses in the custody of the ICC. There is a protection program for the witnesses. We use the term of in custody, meaning that a person is under detention order. So it's a little bit different. If there is no arrest warrant against someone, then there is no need to have them in detention. But there is a legal protection program for the witnesses. I cannot confirm if for this specific case there are witnesses under protection or not. Confidentiality is key in order to ensure the safety and security of the witnesses, but also of other people that might be totally unrelated, but because of rumors, they might be put at risk. So I would invite you and everyone not to speculate on who might be the witnesses. The witnesses are protected by the ICC, taking measures that are appropriate to the risk that they may be running because of their interaction with the ICC, whether they are defense witnesses or accusation witnesses. The ICC offers the adequate level of protection to all the witnesses that may be called by either party for the proceedings.
Perhaps a better word is protective custody, not even?
As I said, we have a protection program. We admit witnesses in protection program, but I would not speculate if there are defense witnesses or accusation witnesses that may be under this protection. We offer the protection depending on the level of the risk, and we take the appropriate measure for that.
And what phase in the ICC pre-trial process is the Duterte case now? Would you say it is on schedule?
Well, for now, as we have indicated, we are at a pre-trial phase. During this pre-trial phase, the judges need to ensure several elements to be put in place in order to make a decision on the confirmation of charges, which is a key step in the pre-trial phase, because if no charges are confirmed, then the case would stop at a pre-level phase, at a pre-trial phase. If one or more charges are confirmed, then the case can move to a trial stage. So the confirmation of charges hearing is a key moment. And during this key moment, the judges will be listening to the prosecution, but also to the defense and to the legal representative of victims if they are authorized to participate in the proceedings. Of course, legal representative of victims are not a second accusation. They are there to express the observation and points of views of the victims, but the charges are brought by the prosecutor, and it is for the prosecutor and his team to provide sufficient evidence to the judges in order to try to convince them to move the case to a trial level. So between now and September, what's going to happen is the preparation for this important milestone. That means that, in practical terms, the prosecutor would need to disclose to the defense team the evidence on which he intends to rely during the confirmation of charges hearing. Because the defense, of course, has the right to prepare, has the right to know what are these evidence, to be able to check them, to counter-investigate them, and if there are witnesses that they are called, of course, the defense would have the possibility to cross-examine them, and also the defense might be requesting also to admit and to call witnesses. Of course, the confirmation of charges hearing is not a trial. A trial is a lengthy process at the ICC. The confirmation of charges hearing is only 3 or 4 days. There is usually very limited number of witnesses, if there are witnesses at all, that are called to participate at the confirmation of charges hearing. It's a couple of days where the prosecutor will be presenting key evidence in order to convince the judges that the case deserves to move to a trial. And of course, the defense will be presenting its own arguments. After the hearing, which is scheduled in September, as you have mentioned, the judges may give additional time for the parties to present written observations to complement their argumentation. It may happen or not, but if it happens, then the deadline of 60 days for the judges to render their decision will start running from the time when this period of completion of the confirmation of charges will be done. So after 60 days, the judges will then decide whether they confirm the charges in total or in part, or whether they reject the charges, or whether they ask the prosecutor for additional evidence or for a different legal argumentation. So it's only then that we would know what would be the next stage. And of course, the decision on the confirmation of charges itself may not be satisfactory to either the defense or the prosecution, or to both. But in this case, they cannot appeal it directly. They need to be authorized to appeal it. But there is a possibility that they may be granted to appeal this decision. And then eventually it will be for the appeals chamber to confirm or not the decision of the pretrial chamber. And only if we know that there are charges that are confirmed, then we can start preparing for a trial. If no charges are confirmed, then the case would stop, as I mentioned, at the pretrial level.
All right. Well, Dr. Abdallah, I quickly just wanted to go back to the arrest warrant where the ICC cited 43 cases. You have the camp of Mr. Duterte arguing that you cannot establish the widespread and systematic killings if you're just basing it on 43 cases. So please help us understand, is there really a required number in order to establish a crime against humanity, or is one case enough?
No, there is no required number. It's not a matter of numbers. The nature of the attack, whether it's widespread or systematic, is an important element to qualify an illegal conduct as a crime against humanity. So a murder or rape or torture or other illegal conducts, they may be called crime against humanity only if they are committed according to a common plan and within the context of a widespread or systematic attack against civilian population. Now, this is different from the actual number of people that may be injured or killed during these attacks. So there is a first question of whether or not there were attacks and whether they were widespread or systematic. And then there is a second question about the type of illegal conduct that may have been committed during these attacks. And then we can look at the matter which is important of the gravity of the crimes. Are they of a sufficient gravity or not? And the issue of gravity is not in terms of numbers, but in terms of impact on a community or on individual lives, on the short term or on the longer term. And that is something that may be evaluated by the judges, of course. Now, the issue of the 43 incidents or killings that the judges consider that there are reasonable grounds to believe that they happened is a matter of a kind of a sample of eventual and alleged illegal conducts that may have been committed during widespread or systematic attack. But of course, this was for the purpose of the arrest warrant. And the issue would be before the judges to check whether indeed there was systematic widespread attack, whether or not the crimes were of a serious gravity, and whether or not Mr. Duterte has any responsibility in it. So these are questions that will be put to the judges, and of course it would be for the judges to decide on them. But as I mentioned, the issue of the number of 43 is a kind of a sample of the types of impact of these attacks and the incidents that may have been committed during it. And it would be for the prosecutor, of course, to bring the evidence on the nature of the attacks and on the gravity of the incidents.
I also wanted to talk about the possibility of an interim release for Mr. Duterte. I mean, you have his camp saying it's not a priority for them right now, but should they decide to apply for a temporary release, what factors will be considered by the ICC, and does that include the actions of his supporters? Because we have one Filipino ICC-accredited lawyer saying it will be considered by the ICC. Is that accurate, Dr. Fadi?
Well, of course, allow me to insist that I cannot speculate on what the judges might or not decide. First, the defense would need to make a request, and then after that, of course, we will see what the judges would decide. But I can explain the general framework of why the arrest of a suspect would be necessary in the views of the ICC judges. It's normally either because this person appears not to be willing to voluntarily cooperate with the ICC and to appear before the judges when asked, and then there is a need to issue an arrest warrant and not a summons to appear, or because this person would have the capacity and the means either not to return before the judges or to kind of put obstacles and create issues for the investigations or for the safety of victims or witnesses, or might appear to be continuing to commit alleged crimes. These are usually the elements that the judges would be looking at in order to decide to issue an arrest warrant instead of summons to appear. Now, there is a general rule, which is the presumption of innocence of the suspects, unless and until after a trial they are convicted and judges are convinced beyond any reasonable doubt of their guilt. But until and unless this happens, of course, the suspects are presumed innocent. So the general rule would lead that, in general, it would be the right to apply for interim release, and freedom should be the general rule, unless, as I mentioned, there are specific reasons of not cooperating or staying at large and not returning before the judges, or creating obstacles and risks for the investigations and eventually for the witnesses' safety or for the victims, or continuing to committing crimes. So the judges will have to look at these matters, will have to look whether or not there are measures that can be put in place to ensure that the suspect would be returning, would be cooperating, would not be creating any obstacles for the investigations or risk for the witnesses, or will not be allegedly continuing to commit crimes, and whether this type of measures can be accepted by a state that would accept the temporary release of a suspect. So there is a set of elements that may be discussed before the judges, and it's only for the judges to decide on.
Okay, and while we wait for that appeal to even come to fruition, we are all wondering here as well how the president is really doing. How are his days like? What's his schedule like? Does he get human interaction? We've heard bits and pieces from his daughter, the vice president. Apart from that, and meetings with lawyers were basically going blind. Are you at liberty to share with us, Doctor, how his typical day goes? And is that a case-to-case basis also per prisoner, or is there a standard schedule to be followed by everyone inside the detention center?
Well, first, it's important to consider that all ICC detainees are not prisoners. They are not in a prison. They are in a detention center. And of course, the rules that are applicable at the detention center are different from the rules that are applicable in a prison. And the reason for that is, of course, that they are presumed innocent. But the judges consider that there are reasons that impose that they should be arrested. Now, in the detention center, we have also a general principle to apply, which is to respect the private life of all detainees. So I'm not at liberty of discussing the details for that, but I can assure you that the ICC is taking all the necessary measures to protect the well-being and the health of all the detainees, and that all the detainees have specific rights at the detention center, including communication with their counsel, and including certain visits, mainly and specifically family visits. But we cannot discuss in details this matter out of respect for the private life of the detainees.
And Dr. Fadi, I know the ICC allocates 40,000 euros a month for legal assistance for the detainees, but does that apply only to indigent detainees, or in this case, particularly for Mr. Duterte?
No, there is a general legal aid program at the ICC that can be used to cover the expenses of a legal representation, either for the defense or for the legal representation of the victims as well. And for that purpose, the ICC would have to check whether or not a detainee has sufficient resources to be able to cover the expenses of his legal representation. And sometimes decisions can be made on a temporary basis until and pending the completion of a financial investigation about the resources that a person has. And if the court determines that there is no sufficient resources for this specific individual to cover his or her legal representation expenses, then we can use the legal aid program of the ICC, which covers of course, the constitution of a defense team and a certain amount of money for their investigations and counter-investigation in relation to the evidence that might be submitted by the prosecutor. And the amount that is allocated to the defense teams under the legal aid program can vary depending on the phases of the proceedings and on the amount of work that is necessary.
And lastly, may you respond to criticism, sir, that the ICC targets leaders from weak countries and avoiding action on leaders of the more powerful countries, thereby affecting global support for the ICC?
Well, I think if you look at the list of ICC arrest warrants, I think that you will see very clearly that this accusation is simply not true. The ICC has opened investigations in various regions of the world, in Latin America, in Africa, in Asia, and in Europe. There has been arrest warrants that have been issued in the context of the investigation in Palestine or in Ukraine or in other places against individuals of a very high political profile. The issue is that sometimes the arrest warrants are pending, but that's not up to the ICC. The implementation of the arrest warrants of the ICC requires the cooperation of states that are parties, and states that are not parties can cooperate on a voluntary basis. And this is important to make sure that justice prevails, to make sure that victims knows the truth, and that individuals are held accountable.
Well, we thank you very much, sir, for the clarifications and for talking to us here on The Big Story. Fadi El Abdallah, spokesperson of the International Criminal Court. Thank you once again.